Professionals in the criminal justice system serve and promote the interests of law and justice. So before we explore ethical issues and dilemmas that confront them, let's begin with a discussion of justice itself. Justice is not something for which we should feel grateful, but rather something upon which we have the right to insist. Justice should not be confused with good. Some actions may be considered good, but not demanded by justice. It is important to understand that what is just and what is good are not always the same. People can be described as displaying unique combinations of generosity and selfishness, altruism and self-interest. Some insist that the need for justice arises from the nature of human beings and that we are not naturally generous, open-hearted, and fair. On the other hand, if we are to behave all the time in accordance with those virtues, we would have no need for justice. On the other hand, if humans were to always act in selfish, grasping, and unfair ways, we would be unable to follow the rules and principles of justice. Therefore, we uphold and cherish the concept of justice in our society because it's the mediator between people's essential selfishness and generosity. In other words, justice is the result of a logical and rational acceptance of the concept of fairness in human relations. Fairness is related to the concept of equal treatment. Equality refers to equal shares or equal treatment as well. There is a predisposition to demand equity or equal shares for all or equal shares for similar people. The concept of equality is also present in retributive justice in the belief that similar crimes should be punished equally, equal justice for all. In contrast to the concept of equal shares is the idea of needs or deserts. In other words, we should get what we need or, alternatively, we should deserve by status, merit, or other reasons. Impartiality is also related to the concept of equal treatment. At the core of our system of criminal justice is the theme of impartiality. Our symbol of justice represents with her blindfold impartiality towards special groups and with her scales proportionally just punishments. Impartiality implies fair and equal treatment of all without discrimination and bias. It is hard to reconcile the idea of blind justice with taking individual circumstances into consideration when determining culpability or punishment. Most would argue individual differences and circumstances should be taken into consideration, if not during finding of guilt or innocence, at least when sentencing occurs. If the blindfold of Lady Justice signifies no special treatment for the rich and powerful, then it must also signify no special consideration for the young or the desperate, or for any extraordinary circumstances in a criminal case. Justice originated in the Greek word dike, which is associated with the concept of everything staying in its assigned place or natural role. This idea is closely associated with the definitions of justice given by both Plato and Aristotle. Justice is one of 4 civic virtues, the others being wisdom, temperance, and courage. In an ordered state, everyone performs his or her role and does not interfere with others. Each person's role is the role for which individuals are best fitted by nature, thus natural law is upheld. Moreover, it is in everyone's self-interest to have this ordered existence continue because it provides the means to a good life and appropriate human happiness. Aristotle lived in a time where slavery was an accepted practice and people believed that slaves were of different aptitude or character from free men. Even Aristotle recognized, however, that injustice may occur when someone was placed into slavery. Aristotle associated justice with the law. If a person violated the law, he would be considered unjust. However, he didn't view justice solely as a function of law. A person's dealing with other individuals in all areas of life determined whether he could be considered just or unjust. Distributive justice concerns what measurement should be used to allocate society's resources. For instance, this type of justice would include issues such as affirmative action, welfare, free schooling, and other goods and opportunities, and how society distributes them among its members. Corrective justice concerns unfair advantage or undeserved harm between people. Justice demands remedies or compensations to the injured party. The concept of appropriate and just allocation of society's goods and interests is one of the central themes in all discussions of justice. The goods that one might possess include the following: economic goods like income or property, opportunities for development like education or citizenship, and recognition, honor, or status. If there was enough of everything for everyone, goods, opportunity, and status, issues of distributive justice are less likely to arise. The various theories can be categorized as egalitarian, Marxist, libertarian, utilitarian, depending on the factors that are emphasized. Egalitarian theories start with the basic premise of equality or equal shares for all. Marxist theories place the need above desert or entitlement. Libertarian theories promote freedom from interference by government in social and economic spheres. Therefore, merit, entitlement, and productive contributions are given weight over equal shares. Utilitarian theories attempt to maximize benefits for individuals and society with a mixed emphasis on entitlements and needs. John Rawls' theory of justice is perhaps the best-known modern conception of justice. He combines utilitarian and right-based concepts in his theory of distributive justice. Basically, he proposes an equal distribution unless a different distribution would benefit the disadvantaged. Rawls believes that any inequities of all society should be to the benefit of those who are the least advantaged. Each person is to have an equal right to the most extensive total system of basic liberties comparable with any similar system of liberty for all. Social and economic inequities are arranged so that they're both reasonably expected to be everybody's advantage and attached to positions and offices open to all, except when inequity is to the advantage of those least well off. Rawls uses a heuristic device that he calls the veil of ignorance to explain the idea that people will develop fair principles of distribution only if they're ignorant of their position in society, for they just as easily may be have-nots as haves. There is a connection between distributive and corrective justice. If it is true that socioeconomic status predicts criminal predisposition, should we care? Is it fair that poor people tend to end up in prison and those with more resources usually receive less punishment? Corrective justice concerns unfair advantage or undeserved harm between people. Justice demands remedies or compensations to the injured party. Substantive justice concerns just deserts, in other words, the appropriate amount of punishment for a crime. Substantive justice involves the concept of just deserts, or how one determines fair punishment, and procedural justice concerns the steps we must take before administering punishment. Substantive justice refers to the inherent fairness in what we do to people in the name of justice. The concept of retributive justice is one of balance. Justice demands that the criminal must suffer pain or loss proportional to what the victim was forced to suffer. Retributive justice justifies punishment simply because the offender deserves it. However, utilitarian justice supports punishment only if it benefits society. A utilitarian framework of justice would justify punish based on deterrence. In some cases, retributive notions of justice and utilitarian notions of justice may conflict. If a criminal is sure to commit more crime, the utilitarian could justify holding him in prison as a means of incapacitation. But the retributive approach to just punishment would not hold anyone past the equal time to the crime. Deterrence is the primary reason to punish under a utilitarian system, but desert is the only determinant of a retributive justice system. We subscribe to both utilitarian and retributive rationales for punishment. Amid any discussion of the costs and benefits of prison programs, diversion programs, or the correct punishment for different groups, the concept of desert is ever present. We turn now to the procedure of administering punishment, our legal system. Law includes the procedures and rules used to determine guilt, decide punishment, or resolve disputes. It is important to keep in mind that justice and the law are not the same thing. You might think of justice as the concept of fairness, while the law is a system of rules. In our system of justice, due process exemplifies procedural justice. Our constitutional rights of due process, found in the 5th, 6th, and 14th Amendments, require careful inquiry and investigation before punishment or forfeiture of any protected right can be carried out by the state. An individual has the right to due process whenever the government seeks to deprive the person of a protected right of life, liberty, or property. Due process is the sequence of steps taken by the state that is designed to eliminate or at least minimize error. Procedural protections may include the following: notice of charges, a neutral hearing body, cross-examination, the right to present evidence, representation by counsel, statement of findings, and appeal. The importance of treating people fairly and providing due process protections is a theme that runs only through the law, but also through ethics. Now there's a national registry of exonerations created by the University of Michigan and Michigan State Law Schools and the University of California Irvine Norwick Center for Science and Society. The register gathers together all the known cases of false convictions or cases where convictions have been overturned because of egregious errors or misconduct in procedural justice. Currently, 2,009 cases are in the registry. Almost half, or 47% of cases, involve black defendants. About 40% were homicide cases, and about half the cases involved official misconduct. Wrongful conviction is a conviction of a person accused of a crime which, in the result of subsequent investigation, proves erroneous. The Innocence Project was created by Barry Scheck and Peter Newfield in 1992 at Cardozo Law School. The Innocence Project now exists in sites across the country. The project is an affiliation of groups of lawyers, journalists, and often students in many states that identify cases where people have been falsely convicted and there's DNA evidence still on file that could be used to prove or disprove their innocence. Studies of wrongful conviction should distinguish between true innocence and those cases where official misconduct or error requires a new trial, but the individual might still be guilty. Both types of cases might be counted as exoneration totals. Confirmatory bias results in fixating on a perceived notion or ignoring other possibilities, such as focusing on a specific suspect during a police investigation. Several studies have been used with different sources to estimate wrongful convictions. These estimates range from 0.5% to 15% depending on which sources are used. The growing body of information on wrongful convictions illustrates the fact that procedural safeguards to minimize error and promote procedural justice can be put in place, but these rules and procedures can be subverted consciously or unconsciously by police and prosecutors who are pursuing a conviction. There is strong evidence that those two aspects of procedural justice are differently experienced depending on what race or ethnic group you belong to. There's a large difference in the perception of blacks and whites regarding the criminal justice system. In a combined Gallup poll of 2011 through 2014, 59% of whites, but only 36% of blacks had a great deal or a lot of confidence in police. In the aggregated polls of 2014 through 2016, the percent of whites decreased slightly to 58%, and only 29% of blacks had a great deal of confidence in the police. In the 2011 through 2014 poll, about 59% of whites stated that the honesty and ethics of police officers was very high or high, compared to 45% of blacks. In more recent results, 60% of whites, but only 28% of blacks believed that the honesty and ethics of police was very high or high. In the latest poll, 76% of blacks say that the justice system is biased against blacks, compared with 45% of whites. A recent study by the National Registry of Exonerations found that blacks are about 7 times more likely to be wrongfully convicted of murder than whites, accounting for a disproportionate share of exonerations. They also spent 4 years longer on death row than wrongfully convicted whites. Studies show that there seems to be a difference in the sentencings of blacks and whites, unexplained by other sentencing factors, like the seriousness of the charge or criminal history. Blacks are also less likely to receive bail and receive harsher plea offers. Interestingly, one study showed that black judges give a black juvenile defendant 14% longer sentences than white juveniles, and white judges give white offenders longer sentences. Researchers speculated that judges could be reacting unconsciously, sympathetically to same-race victims. It could also be because of more familiarity with same-race offenders, or it might be because judges were worried about seeming prejudiced. Racial profiling studies continue to show that black drivers are more often stopped for minor traffic offenses, more likely to receive tickets rather than warnings, and more likely to experience auto searches. But there is less likely to be any contraband found in searches of black drivers than white drivers. The disproportionate number of arrests that lead to lost jobs, and tickets and citations resulting in fines and late charges when they can't be paid, are creating a widespread poverty tax on minorities, wherein the criminal justice system differentially draws dollars from those least able to pay. Employing empirically based procedural justice research and community policing models to improve police-citizen interactions in minority communities may be effective tools to address crime in those communities. The issue of race permeates the criminal justice system. In a system with a primary emphasis on the victim rather than the offender, money would be spent on victim services rather than on prisons. It would be victims who would receive the job skills training, not offenders. Some of the money that now goes to law enforcement and corrections would be channeled to compensation programs for victims of personal and property crimes. Offenders would be peripheral figures. They'd be required to pay restitution to victims, and punishment would occur only if they did not fulfill their obligation to their victims. Although the restorative justice movement does not propose quite this level of radical restructuring, it does dramatically redesign the justice system and offers a new alternative to retributive justice. Restorative justice is a term used to describe programs that seek to move compensation back to center stage in the justice system instead of retribution. A similar but not identical philosophy has been called peacemaking justice. Programs that require the offender to confront the victim and provide compensation, and programs that place the victim in the middle of the process of deciding what to do about the offender can be categorized under the restorative justice rubric. The propositions of this movement are as follows. Justice requires restoring victims, offenders, and communities who have been injured by a crime. Victims, offenders, and communities should have the opportunity to be a fully active part of the justice process. And government should restore order, but the community should establish peace. In retributive justice, the question is, who did it? Well, in restorative justice, the question is, what is the harm? In retributive justice, the question is, which laws were broken? Well, in restorative justice, the question is, what needs to be done to repair the harm? In retributive justice, the question is, what should the punishment be? Well, in restorative justice, the question is, who is responsible for this repair? One recent author noted that today's field of restorative justice can be broadly differentiated into 4 key areas: victim-offender mediation schemes, conferencing based on ancient concepts, peace circles, and the realm of international crimes. Victim-offender mediation or victim-offender reconciliation programs involves victims and offenders meeting and agreeing upon restitution. While legal sanctions usually do not make the victim whole or change the offender, restorative justice attempts to do both. What is the role of moral duty of individuals when laws and government edicts are themselves immoral? Unjust laws have the following characteristics. They're degrading to humans, they're discriminatory against certain groups, they're enacted by unrepresentative authorities, and they're unjustly applied. Martin Luther King Jr. said, "An unjust law is one that is consistent with morality. An unjust law is any that degrades human personality or compels a minority to obey something the majority does not adhere to, or is a law that the minority had no part in making." Civil disobedience is voluntary disobedience of established laws based on one's moral beliefs. It is a public, non-violent, conscientious yet political act contrary to the law, and usually done with the aim of bringing about a change in the law or politics of the government. We should always remember that the law is considered the basement of morality. Even if you never break a law, that does not automatically mean you're a moral person. There are immoral acts that are not illegal, and once in a great while some laws are immoral.